There's a legal structure that was used by land barons, railroad magnates, and old money families in the 1800s to hold property anonymously. A structure so effective at separating your name from your real estate that when a creditor, an attorney, a process server, or a public records search tries to find out what you own, your name does not appear anywhere. Not in the county recorder's office, not in the tax assessor's database, not in any public filing. The property exists in the records, the ownership structure is registered. But what is registered is a name that is not your name. A trust with a number or phrase, and the beneficial interest, the actual ownership, is held privately in a document that no public agency has ever seen or recorded. This structure is called a land trust. It is not new. It is not exotic. It has been used in Illinois since the 1890s, adapted across multiple states through the 20th century, and refined into one of the most powerful asset protection and privacy tools available to ordinary property owners. It costs less than a few $100s to establish in most states. The annual maintenance is minimal. And once in place, your home, your rental property, your commercial real estate, any property you hold, becomes effectively traceable only to an entity whose beneficial ownership is not a public record. Attorneys who specialize in asset location, the lawyers hired by creditors and plaintiffs to find what you own before suing you, charge hundreds of dollars an hour to search property records. When the records lead to a numbered trust and no further, they have nowhere to go. The search ends, the lawsuit targets someone else, or it does not happen at all. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The land trust has its deepest American roots in Illinois, where the concept was developed in the late 19th century by Chicago Title and Trust Company, one of the oldest title insurance companies in the country. The structure was originally designed to facilitate large real estate transactions, where multiple investors wanted to pool ownership of a property without each investor's name appearing in public records, and without the property being subject to the probate process when one investor died. The trustee held legal title. The investors held beneficial interests. The public saw the trustee. The investors remained private. By the early 20th century, wealthy families across the Midwest had adopted the structure for personal real estate. The appeal was multifaceted. Privacy was the primary driver, but the land trust also offered probate avoidance, simplified transfer of ownership, and protection against certain types of judgment liens. In Illinois, the structure became so common that it is now specifically codified in the Illinois Land Trust Act. Florida adopted its own version, codified in Florida statutes, Section 689, 011, known as the Florida Land Trust Act. Other states, including Indiana, Virginia, and North Dakota, have similar statutory frameworks. And, in states without specific land trust statutes, the common law trust principles apply, allowing similar structures to be created even without explicit legislative authorization. The mechanics are straightforward. You create a revocable living trust and name it something that contains no reference to your personal identity. The trust name might be the address of the property followed by the word trust or number or any designation that does not connect to you. You appoint a trustee. This trustee can be yourself, a trusted individual, or a corporate trustee such as a title company or trust company. The trustee holds legal title to the property in the name of the trust. You, as the beneficiary of the trust, hold the actual ownership interest. The beneficial interest is documented in a private agreement between you and the trustee, a document that is not recorded anywhere and has no public existence. When the deed is recorded in the county land records, it reads something like this: Jane Smith, trustee of the 742 Evergreen Terrace Land Trust, dated January 15, 2024. Anyone searching public property records sees the trust name and the trustee's name. They do not see yours. If the trustee is a corporate entity, not even a personal name appears. The trail ends at a trust with an address or a number. The beneficial owner, the person who actually controls and benefits from the property, is invisible. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete land trust formation guide, state-by-state statute reference chart, trustee selection criteria, beneficiary interest assignment templates, and the exact deed language required to transfer property into a land trust correctly. The link is in the description, but stay right here. The asset protection benefit goes beyond mere privacy. In many states, a judgment against you personally cannot automatically attach to property held in a land trust of which you are the beneficiary. This is because the lien attaches to legal title, and legal title is held by the trust, not by you. A creditor who obtains a judgment against you must then seek a court order to reach your beneficial interest in the trust, which is a separate and more complex legal proceeding than simply filing a lien on property in your name. This adds time, cost, and uncertainty to any attempt to collect against your real estate assets. And time, cost, and uncertainty are the three factors that cause most creditors and plaintiffs' attorneys to settle for less, pursue other targets, or walk away. privacy protection is real and documented. A 2021 investigative report by the International Consortium of Investigative Journalists as part of the Pandora Papers investigation found that anonymous land trusts and similar structures were used by thousands of property owners across the United States to hold real estate without public disclosure of beneficial ownership. Unlike many countries that have implemented beneficial ownership registries requiring disclosure of the true owners behind trusts and corporate structures, the United States has no comprehensive federal beneficial ownership registry for real property. The Corporate Transparency Act of 2021 requires certain business entities to disclose beneficial owners to the Financial Crimes Enforcement Network, FinCEN. However, the Act's application to land trusts and real property holding structures is complex and still being interpreted through regulatory guidance. If you have made it this far, you already know more about land trust privacy than 99% of homeowners who have their address, their name, and their equity sitting exposed in every public database in the country. Subscribe and share this video. The practical implications extend beyond lawsuits. When you apply for a mortgage or a home equity line of credit, the lender pulls public records and sees your name associated with the property. When a market research firm compiles property data, your name is in their database. When a data broker purchases county records, your home address is linked to your name and sold to anyone who wants to buy it. When someone wants to find out what you own before deciding whether to sue you or how large a settlement to demand, a simple property records search in your county answers the question in minutes. A land trust does not make you invisible to the government, to your lender, or to law enforcement with proper legal process, but it makes you invisible to the preliminary public records searches that determine whether you are worth pursuing. Now let me give you the exact steps. Step 1. Determine whether your state has a specific land trust statute or whether you will rely on common law trust principles. Illinois, Florida, Indiana, Virginia, and North Dakota have specific statutes. Most other states permit similar structures under general trust law, but the specific protections and court interpretations vary. Step 2. Draft the land trust agreement. This document establishes the trust, names the trustee, identifies the property, and specifies the beneficial interest. For a single owner, you're typically the sole beneficiary. The agreement should be drafted or reviewed by a real estate attorney familiar with trust law in your state. Step 3. Prepare a deed transferring the property from your name to the trustee in the trust's name. This deed must be properly executed and notarized according to your state's requirements. The deed is the only document that is publicly recorded. Step 4. Record the deed at the county recorder's office. From this point forward, public records reflect the trust as owner, not you personally. Step 5. Maintain the trust properly. Keep the beneficial interest documentation private and secure. If you want to transfer your beneficial interest to another person, you do so by assigning the interest, not by recording a new deed, which keeps the transfer private. Step 6. Inform your lender or mortgage servicer if you have an existing mortgage. The due on sale clause in most mortgages technically allows the lender to call the loan due if ownership is transferred. However, the Garn-St Germain Depository Institutions Act of 1982 contains an exception that allows transfers into revocable living trusts, where the borrower remains a beneficiary without triggering the due on sale clause. Total cost of establishing a land trust, typically between $200 and $500 in legal fees for document drafting, plus standard recording fees at the county level, typically between $20 and $100. Total annual maintenance cost, minimal, typically limited to any trustee fee if you use a professional trustee, and annual trust upkeep. I need to be honest with you, a land trust is a privacy tool, not an impenetrable shield. First, once a creditor knows a land trust exists and obtains a court order, they can potentially compel disclosure of the beneficial ownership. The trust slows and complicates the process, but does not permanently block a determined creditor with a valid judgment. Second, the land trust does not protect you from the IRS. Tax authorities can pierce trust structures when they have cause. Third, in some states, the asset protection benefits of a land trust are limited. Courts in certain jurisdictions have been willing to reach beneficial interests relatively easily compared to other trust structures. Fourth, the Garn-St Germain exception for due on sale clauses requires that the transfer be into a revocable living trust where you remain a beneficiary. If the trust structure does not meet these requirements precisely, your lender may technically have grounds to call the loan. Fifth, a land trust provides privacy from public record searches, but does not make you invisible in legal proceedings where discovery is available. Your great-grandparents, who owned land in the era before computerized public records, had a natural privacy that digital infrastructure has systematically destroyed. In the 19th century, finding out what someone owned required a physical trip to the courthouse and hours of manual record searching. Today, any attorney with a $30 monthly subscription to a property data aggregator can identify everything you own in every county in America in under 5 minutes. The land trust does not restore the past. It restores a layer of friction that makes your property one step harder to find than your neighbor's. And in the economics of litigation, one step harder is often the difference between being targeted and being passed over. Subscribe and share this video. Every share puts the ghost deed in the hands of someone whose property is sitting exposed in public records right now. The next vault opens soon, and what is inside will show you how to legally bankrupt yourself on paper without losing a single asset you actually own.